On to our final speaker this afternoon, who is Mark Seely. He's the principal of SciPubLaw, which is an organization that provides some services to the publishing and library communities with regard to legal issues that they're facing. And we're going to be talking specifically about the legal issues in controlled digital lending. Always interested to hear what Mark has to say. So, Mark, you can pull up your slides.
Thanks, Todd. Trying to do that now. It looks like
and there you go. Just hit present, and you are good to go. Can hear you fine.
Very good. So, like William, I also have a connection to Elsevier. I was the general counsel there until the end of December 2017. So there seems to be a theme here. But I'm doing a bit of consulting and a bit of teaching now in my retirement, and was really pleased to be asked to talk about questions about essentially digital interlibrary loan. So the CDL in my topic here is a concept and a proposal, I think, called controlled digital lending, which was released in some positions in white papers, and I suspect actual processes beginning late last year, I think in September of last year. And I was asked to really comment about the legal issues raised in this proposal, and therefore I had to kind of review and go through, remind myself again of some of the history of some of these provisions. And as I think we can all imagine, the question about interlibrary loan, or sometimes referred to by some sectors as more like a document delivery, does raise controversies and always has between publishers and librarians, notwithstanding the fact that there's a lot of common ground and commonality. So I want to take a look at this and tear it apart a little bit to talk about the issues. I think the most relevant sections of the US Copyright Code having to do with this question about digital interlibrary loan or interlibrary loan in general are going to be sections 108 and 107 of the Copyright Code. And there's a very curious relationship between these two sections.
Mark, I'm sorry to interrupt you. This is Jill. Could I ask you to speak just a little bit louder? I'm afraid we're not catching every word.
Gotcha.
Thanks.
We'll try to do that. I think I remember that it was a little bit too low before.
Okay, thanks.
So on this curious relationship, what we have is in section 107, the general fair use exception. Now, fair use is meant to be a very flexible instrument, which notes that certain types of uses of a copyrighted work might not be an infringement if it's being done for a variety of socially acceptable, socially important purposes, including scholarship and research. And as part of that analysis, it sets out the famous four-factor analysis, which I'll discuss in more detail later. On the other hand, section 108 is very specific and deals with both library preservation principles and the question of interlibrary loan. Now, section 108 was last revised a little bit in 1998. But the fact is that most of section 108 comes from the 1976 Copyright Act, which is still the kind of biggest and most fundamental copyright law that's still in existence in the US. So that's a long time ago, 1976. And by the way, the 1976 took many years to actually get implemented. What happened in 76 also was the idea of a kind of bipartisan discussion and a bipartisan set of agreements that came to be referred to as the CON2 guidelines. because at that time, the legislature, Congress realized that it really needed to have the input of specialists and the communities that would be most relevant in these questions. And so they asked that group to go off and to develop some guidelines that would give more meaning and context to some of the legislative principles about how interlibrary loan should not substitute for subscription or purchase. And it should be understood to be an additional right, not a fundamental core right. So the Conti report came out at that same time, and it has the rule of 5. Now, they also describe more specifically what kinds of copying might amount to an impact on subscription or purchase. So it's also helpful from the perspective of explaining those matters. The rule of 5 is interesting because it deals with periodical publications. And the rule of 5, as I'm sure many of you will know, has to do with recency, if you will, recent publications, so publications published within the last 5 years, and some type of limit in terms of the amount of articles that can be requested by the borrowing library in a given year, up to 5 articles, hence the rule of 5. So there was a lot of detail in Section 108. However, it has not been essentially amended, and it does not really address the digital issues, which I think leads then to my discussion points about prior attempts to change the law and what the CDL proposal looks like. Now, in Section 107, it's the ultimate flexible wildcard with the 4 factors. And there may be a question about why do we have these 2 sections, or why is it that legally we think these 2 sections address the question of copying in libraries. And I think that it is fairly simple. And I think it's because the drafters in 1976 realized that Section 108 is very specific and very helpful in that specificity, but that you cannot predict every development in the law or in technology or in, frankly, just common usage. And therefore, Section 107 is there as that kind of wild card to create and give that kind of flexibility. And I think that was clearly understood at that time. The drafters of the CDL position, which I suspect many of you have probably looked at, discuss Section 107 a lot. And they discuss also the for sale doctrine, which I think of as generally being about the sale of a used print book, for example, but do not address Section 108 at all. And I don't think that's because of a fear of complexity, because frankly, fair use is remarkably complex in and of itself. I think it's a feeling that perhaps the courts, and they're thinking about things like some of the Google Books cases, for example, have been more supportive of expanding areas of use than has the legislature. And I think that's very much why they have focused on Section 107. So there's been a lot of efforts on Section 108 in the past. And I think that there is broad agreement that Section 108 needs to be updated, and broad agreement that it needs to be updated to really reflect the new digital online environment, but both as to the content itself and as to the delivery of that content online. However, there are still concerns on the part of publishers about questions about security and leakage and exactly what kind of content is being selected. Publishers will be, I think, less concerned about older content, about content that is more specialized, and more concerned about more recent content and content that is more popular, if you will. I think on the user concern, on the user side, there are concerns about the speed and efficiency of any interlibrary loan process. That's understandable, and that's reflected also in a number of projects that libraries have been involved with over the past 20 years. And the working group that was established by the Copyright Office started in 2005 to look at specific proposals and to provide a set of legislative updates that could be reviewed by the Copyright Office and then ultimately Congress. In addition to that, there were publisher pilot projects that were really dealing with ebooks and the question of whether or not ebooks could be used in interlibrary loan processes. And most of those pilot projects actually were in the trade sector. So there's a question that I think we can all ask, which is, well, what happened to all of these projects and all of these proposals and working groups? And I think the short answer to that is that the Section 108 working group did not reach a clear conclusion on the degree to which digital files would have to have technical protection measures or DRM attached to them, and exactly how that would be done, again, to address that security leakage issue. And on the library side, the official positions that I saw, dating back now more than 10 years, was that actually there should be no technical restrictions on digital interlibrary loan, as far as I can understand the proposals and the comments. I might be a little bit wrong about whether or not they haven't been updated, but that was certainly the concept and discussion at that time. So absent a real consensus on fundamental questions like that, I think it would be really difficult to move proposals into the legislative process. And I think the Copyright Office in the end, and interested members of Congress felt that there were probably other issues in the copyright world that had greater consensus or higher sense of urgency. And I think that's what happened there. And I mentioned the Authors Guild Healthy Trust case. We'll talk a bit more about that next. So, as I said, the CDL position relies very much on fair use, Section 107, and to a large extent on calculations of risk and risk assessment. They describe factually the issues that they're trying to address as a 20th century book problem, by which they mean that the length of the duration of copyright is quite long, life of the author plus 70. So they're going back into the early to mid 20th century, and they're asserting that there is not really a viable, substantial electronic book market that's out there that is solving the needs of users and scholars. And therefore, there's a need to expand interlibrary loan to include the digital and to permit scanning of print works to bring those works into the 21st century. Now, I'm not quite sure that I personally buy the argument. I do think that there is probably an argument about early to mid 20th century, but I also think that publishers have been working very hard in the past 20 years to make their content, books and journals available electronically, and in fact have gone back in many cases and scanned and made works that were previously only available in print available digitally. And also quite a bit of licensing and discovery options have expanded. So I would say that there is something of a 20th century book problem But ultimately, the question really is going to be for the library community to think about what the user needs are and what types of demands and requests are coming through. And to make policy based on what the key demands are and what the real market impact is going to be. I mentioned the fair use factors in section 107, and the CDL authors spend quite a bit of time in parsing through those four. Those four, which many of you will know, has to do with the purpose of the use. First, if it's a scholarly or research purpose, I think we can all agree that most interlibrary loan requests are probably going to fall into those categories. And then the second factor is the nature of the work. The idea here is that a work that's more factual, more of that work can probably be copied and still be a fair use. Whereas if it's a work of fiction or a very creative work, more of a trade-oriented work, that the copying should be less of that. I'm not talking about interlibrary alone here. I'm talking about just straightforward copying. So that's the nature of the work. Then the amount used, obviously it's a question of you're using a short extract or using the entirety of the work. Of course, here in interlibrary loan, we're talking about the entirety. And finally, the market effect. I think what's important here, it really is kind of a combination of the fair use factors and then some of those risk elements or risk assessments. One of the things that's talked about in the CDL papers is that there may be some discussion about perhaps limiting CDL to more of those factual or scientific works, which could improve the second factor analysis that we talked about just now. They also describe in a lot of detail the notion of an owned to loaned standard, which would have effect on the market question, the fourth factor. And by owned to loan, what they mean technically is that if the fulfilling library is providing a digital copy, then it has to essentially disable access to that copy or the number of copies perhaps that it has that it's now loaning out, so that there's a ratio and a relationship between the number of titles owned and the number of titles that are loaned. I think they're thinking very much of a book context when they talk about that. And the CDL authors also talk about DRM protection, which I think it is very interesting because, as I mentioned before, the official library organization positions 10 years ago was very anti-DRM. So it's interesting that this is now somewhat pro-DRM. There are other risk elements that they discuss as well, which I think are important. One is litigation aversion. I think many of us have been following the electronic course back case down at Georgia State, which is a case which is mentioned a lot in the CDL papers. That case has been going on for 10 years now. And if anything is going to give you concern or pause about the degree to which litigation is going to resolve matters or clarify matters, that would probably put the kibosh to that. And people don't like to litigate, frankly, whether they have money to spend on litigation or whether they don't. It's just really not something folks like to do. They also talked about the fact that there is sovereign immunity for public institutions. So state agencies and state entities are not susceptible to monetary damages for copyright infringement. They can have injunctive relief, but not monetary damages. And then finally, they talk about the fact that there's a lot of good faith reliance, which is important in terms of individual actors and libraries when they're engaged in copying activity or when they're enabling copying activity by patrons and other users. And that looks to whether or not the requester or the library staff involved in fulfilling the request had a good faith reliance that there was a fair use being made or that was consistent with Section 108. And that good faith will in fact eliminate or reduce in other cases the potential for damages. So that essentially is the discussion in CDL about these matters. So I do want to go back and end on a plea for a bipartisan alternative here. I think that Section 108 of the U.S. Copyright Code is clearly the best method to reduce legal uncertainty. I was struggling to try to think of a metaphor to use about this, and I thought of, if you have a river that's going through a certain area, and if you have a bridge that is pretty reliable, it's pretty sturdy, kind of how it works, it goes across the river, why would you then try to sort of bypass the bridge completely, which I'm analogizing to Section 108, and test instead whether or not you might be able to cross at some shallows and whether there's a ford that's available somewhere. Frankly, there's a lot more uncertainty in the fair use calculation, in the potential for litigation. I think the revision of Section 108 is the best method to go here. Now, that means a lot of discussions, probably more openness about the technological solutions, which are hinted at in the CDL papers, but not really discussed in detail, and perhaps areas of compromise. I think publishers would need to become much more comfortable with the idea of what technology is being used. I think that there could be areas of compromise about types of works or perhaps the era of publication of certain works. And there has to be some discussion about the difference between ebooks, which are being made available often through license mechanisms, and the print books, which were more often just kind of sold on the market. And many of the experiments that I mentioned from a few years ago had to do with ebook files and licensing. Those, I think, have to be understood and discussed. So I think, Todd, that is my conclusion for the discussion, and happy to address any questions.
Thanks, Mark. I'm wondering, kind of reflecting on something that William said, to what extent has the technology and the sharing of content kind of jumped some of these legal questions and not necessarily changed the legal structure, but it's created a situation where, like for example, with Napster years ago, it just became too big of a problem to address through legal challenges or legal means. And by this, I'm talking about the sharing of content, but that there needs to be a fundamentally different approach, which in the music industry led to the creation of like iTunes and a market for individual songs and kind of making it easier. I'm wondering, from your perspective, has is the legal issue been superseded by some of the technological advances and the proliferation of sharing by scholars